Good evening, everybody, and thank you for attending what is our attempt to explain advocacy before the Commission. By way of introduction, my name is Val Gostinik. I'm a Deputy President here at the Commission, and with me is Commissioner Nick Wilson, and between us we'll endeavour to give you a general overview about advocacy, particularly from the Commission's perspective. As with all things and all advice about advocacy, you should take what you can out of this session and try and apply it. That which you think is garbage, discard. My best tip to aspiring advocates is to spend some time watching some professional advocates craft their submissions and their appearances before the Commission or before a court. And most importantly, to practice. The more you do, the better you'll become at it. And those that are at the bar table get an opportunity at the end of this session to practice their skills, because we'll call on them to do a bit of a surprise moot. All right. What we'll endeavour to do this evening is to give you some general tips, if you like, about advocacy from the Commission's perspective. So let's begin with some general concepts. Advocacy, whether it's before a tribunal or a court, or in political life, or working for a community organisation, or representing a union or an employer organisation, is about influence. Advocacy is an attempt to influence a decision that somebody is going to make. In the context of the Commission, what it is that an advocate seeks to do is to try and persuade the decision maker about the most appropriate decision to make in the circumstances, and most importantly, from a decision maker's point of view, to assist the decision maker in making the correct decision. And in doing so, advocacy is about trying to explain your case as effectively as you can, to try and explain the law that applies in a particular case, to try and explain the facts, and also to understand the case that your opponent is putting, and to try and expose the weaknesses in your opponent's case, the case that they're offering against yours. It's also an opportunity to try and explain evidence in context. Again, from a tribunal's perspective, it's important that advocates that appear before the Commission, whether they're lawyers or not, understand some basic professional obligations. Uppermost in those professional obligations is a duty of candour, to be open about the facts, not to mislead a member of the Commission, and again, from a professional advocate's point of view at least, to make members aware of important decisions which affect their decision, even if the decision or authority is adverse to the interests that you represent. It's important that you explain those cases and to try and distinguish them if you can, or to argue, if you're brave enough, that the decision's wrong. Particularly when the member before whom you're appearing was the decision maker. It's always an interesting task. Advocacy, Nick will make some comments about these matters as well, but advocacy begins with the originating application, so that as a person representing a party, you need to ask yourself some basic questions about matters that come before the Commission. The first is, what's the problem that we have that we're asking the Commission to try and fix? Can the Commission help? These are questions that go to jurisdiction, whether we have power to do what a party asks us to do. That we're called the Fair Work Commission doesn't mean that all unfair things that happen are able to be resolved by some miraculous application to the Commission. We have limits to our jurisdiction and our powers which are set out in the Act, so you need to understand what those limits are and ask the Commission to deal with matters that we can properly deal with, and avoid asking us to deal with matters that we can't. And you should familiarise yourself with the power that the Commission has in a particular application, bearing in mind that most powers that we exercise are discretionary. That is, just because we have the power doesn't mean we'll exercise it. You'll need to persuade us in a case that it is appropriate in that circumstance, that factual circumstance, to exercise a particular discretionary power in a particular way. You should also bear in mind the different stages of Commission proceedings, and in particular that the powers may be exercised in different contexts. So the Commission exercises conciliation power or mediation power. Some proceedings of the Commission are undertaken by telephone. Whether or not particular matters are dealt with by telephone and how much of a matter is dealt with by telephone is entirely left to the discretion of the member who has a particular matter assigned to them. I'm not as big a fan of telephone matters other than to deal with preliminary or directions matters than other members. Some members will conduct an entire hearing, for example, in a jurisdictional matter by telephone. That's not my preference. I find taking telephone evidence a difficult matter.
Well, I certainly find it difficult taking evidence by telephone, but probably with the kind of matters I deal with, probably about at least half would be dealt with not in rooms such as this. They're dealt with through telephone conciliation or other means. And it's also important to understand that there's a difference between a telephone conciliation and a telephone arbitration. So often the issues I'm dealing with are actually about trying to mediate an issue by telephone, and so you then don't obviously have the body language that you would normally get sitting face to face with someone. And the reason for that is because they might be in the remoter parts of the metropolitan area, but also interstate in the country, and so it's often not possible to actually deal with people face to face. But it's a lot quicker as well. But it pays as an advocate to understand what you're going into. Don't assume that you're going into a hearing that I'll be making a decision, because very often it will just be about a conversation about, well, what is the problem and how do you propose to resolve it? And then the other side, how do you propose to resolve it as well? It's important you understand those differences at the early stage, because so much of what we do is in that category. Remote links, dealing with it as a mediation or conciliation rather than as a hearing.
Members will often list matters for directions hearings or directions telephone conferences. These proceedings are a two-way dialogue, and quite often I'm surprised by how little preparation parties put into directions hearings and rely on the Commission to simply make directions about how the matter is conducted. Whenever you get a notice of a listing for a directions hearing, you should ask yourself, first of all, this is an opportunity for me to improve my case. Do I need the Commission to make particular orders? For example, do I need particular people to attend who might be unwilling to attend voluntarily? Do I need particular documents to establish my case? Should I ask the Commission to make orders for the production of documents? Are there particular difficulties in some witnesses attending on particular days? Should special directions be made in relation to the attendance of witnesses? Do I require experts to establish particular facts? All of these matters should occupy your mind whenever the Commission lists a matter for directions, because it's an opportunity for you to influence, as an advocate, the outcome of the directions in order to allow you to prepare the best case that you possibly can. Some matters are conducted by way of a conference, and in particular unfair dismissal cases are often conducted by way of a determinative conference rather than a hearing. It's in fact the default position of the legislation to have unfair dismissal application in particular are determined in that way. Now, my experience in these sorts of matters is that where you have professional advocates involved, they prefer the formality of a hearing, and that's fine. But conferences are useful from the Commission's perspective, particularly in dealing with unrepresented litigants who are unfamiliar with court procedure, who might find it intimidating to deal with a matter and explain their case in a coherent way, surrounded by that formality, so that the opportunity to conduct a hearing by way of a conference is an opportunity to take some of the formality away and to make people feel comfortable, and to make the applicant and the respondent or give them the opportunity at least to present the best case that they possibly can.
In such cases, it's probably fair to say that the conference is very free-flowing now, which is a good thing and a bad thing in some respects. But it makes it somewhat difficult if there's a party in the conference who expects it to be heard quite adversarially, but the other party wants it informally. The best advice I can give in that respect is to really understand the relationship, the dynamic that you're going into, what the member has to actually find out of the hearing or conference, and then work to the cues the member might be giving you. Sometimes it requires an advocate in that sort of instance to be quite trusting, I think, of the Commission member to, despite the fact it's free-flowing, still hear the thing quite fairly and independently. The usual sort of flowing of applicant's case followed by respondent's case isn't necessarily what you get in some of those conferences, and you just do need to, fortunately or unfortunately, go with the flow. If you have queries about what it actually means, check in with the member before the conference. What do you expect? What is the procedure? And then if you're still unsure, check in right at the start of the conference. It doesn't hurt to ask questions about how things might occur. Different members may also conduct the conference in different ways. My own procedure, because I'm somewhat lazy in these things, is to sit right at the bench, at the bar table rather, so I'm immediately opposite the unrepresented party. I can see what they're actually looking at. When they start saying this document here, I know exactly what it is. But other members will do it very formally. They will sit here or at the associates table. They will still have evidence through the witness box. So different members do it in different ways, and it pays to just try and understand that before you move into the conference.
One of the key differences in the determinative conference approach is that a member will generally undertake a much more inquisitorial role. So those that are familiar with European civil law systems where judges act almost as the prosecutor or inquirer rather than sitting passively and receiving evidence and relying upon the parties to produce it. And that is a necessary element of fairness in these sorts of proceedings, because unrepresented applicants and unrepresented respondents generally don't know what sort of information they should provide you. It's generally not presented in any particular coherent or logical way, and so it necessarily involves a member becoming much more involved in getting their hands dirty in the proceedings to try and extract from the information that's presented those things that are important in the member making a decision. And there are, of course, the formal hearings and appeals and full bench matters in which you'll all have an opportunity to practice your craft. Before we talk in more detail about the hearing process, I think it's opportune to just say a few things about advocates in particular dealing with chambers of a member and some issues surrounding a tribunal etiquette. There is frequent contact or communication between parties, advocates and chambers, and it's perhaps a product of modern living that communication becomes less formal through email for some reason. Can I suggest that you always should remember when you're receiving a request from chambers signed by the associate, it's at the direction of the member. It's a request from the member, so the response that you give will be seen by the member. An element of civility and formality is usually warranted. Requests come from chambers because the member is interested in something or wants some additional information. So, as an advocate, it's always useful to respond quickly and relevantly to the request. In any proceeding, correspondence with chambers should be copied in to the other side. There are very few exceptions where that shouldn't occur, and certainly it's my practice to remind parties consistently that they need to copy in the other side. These are not private sessions. The other side is entitled to know what correspondence you've entered into with the Commission, and it's always good practice before communicating with a member to alert the other side to the fact that that's what you want to do and why you want to do it. And sometimes it's good to ask the other side whether they'll agree to a particular proposition that you want to advance before the member, before you do so. So have those conversations before you start communicating with chambers. Several documents that are required by the rules on the other side. Again, it's a frequent omission in matters before the Commission that applications or documents are not served. The other side is entitled to know that you've brought an application, or entitled to know that you've filed some document in the Commission, and they do so by way of service. If you have a look at our rules, it'll set out each and every kind of proceeding or form that you're required to fill in, and who it must be served on, and within what time those documents must be served.
Val, one point to make about where people do try to refer to things quite confidentially to us, it's often in my experience, the anti-bullying matters or the agreement matters where people try to and do come to the chambers without going to the other side. Now, in those sort of issues, as far as we can, while it's in the conciliation process, we will try to deal sensitively with the issue. We're not about to put something super confidential to the other side without at least alerting them to the possibility that may have to occur. But we're frequently having conversations with people about these things, and frequently getting to a point where we have to say, enough, from this point onwards we're not engaging with you on the subject, we're simply providing it to the other side. So if you start to see some of those things going on, it's a warning sign, I suppose. But certainly from the Chamber's point of view, we're trying to make sure the file is meticulously kept and scrupulously fair to both sides. Often my associates or any associate of any member will tell you that a lot of their day is spent answering calls from parties. We don't give legal advice. No chambers will give you legal advice. So nice try, but unless you need some administrative assistance or some advice about how to comply with a particular rule, you're not going to get advice about what the most appropriate application is that you should make, how you should make it, how you should run your case, what should be in your submissions. These are matters that you will have to make judgments about, but so far as the administrative workings of the Commission is concerned, the associates will be more than helpful, but not otherwise. And one final point is about manner of communication. Whenever you make a request, if it's by telephone, my associates, and I think all associates will say the same thing, is you'll need to put your request in writing and you will need to copy in the other side. So that you will not get responses to telephone queries unless you have followed up with an email. And there are very, very sound reasons for that. You don't want to have allegations made about a bias, or allegations that you've taken into account matters which the other side didn't have an opportunity to comment on. So there are sound reasons for what might sometimes feel like nitpicky approaches from the Commission's chambers. All right. We'll say a few things about tribunal etiquette and advocacy, and then move into case preparation and advocacy in the course of a hearing.
most lawyers, that is, lawyers who work for firms and all paid agents will obviously need to seek permission to represent their members, their clients in a hearing, and permission to be represented is a discretionary power that's exercisable by the Commission if the Commission is persuaded on one of the two limbs. There are three limbs in Section 596, but essentially there are two. It's the efficiency ground and the fairness ground. Different members have different views about the extent to which lawyers should be permitted or granted permission. Some are more flexible than others. That's the nature of the exercise of a discretion. For my own part, and generally speaking, lawyers will assist in an orderly conduct of the proceeding. They will at least be able to articulate succinctly the issues that need to be determined and present a case in a manner that's that is structured, and that it gives me an opportunity to properly examine the issues. Some members will require more persuading than others, I think that's fair to say, but that's the nature of the exercise of a discretion, and you'll need to be prepared to address that issue. You shouldn't just assume that you'll be granted permission, and there have been some cases in which both parties have sought permission and been denied. Again, that's the nature of...
If you have any questions about the subject before you actually come to the Commission, then it's best to clarify that beforehand. Most members will, if you ask it the day before or the week before, they will try and give you an indication about how they will determine it. It's somewhat rare, I think, in my experience, where a refusal would be given on the day, but nonetheless those occasions do exist. My own view is that I think I'm flexible. Having said that, there have been occasions where I've refused it. It's usually been where I'm simply not satisfied from the documents so far that there's certainly no question of fairness, but I'm not getting the efficiency, taking into account the complexity of the matter that I would expect. You take your chances. But as I said, if you're concerned about it, if your client's concerned about it, best to check the day or so before.
In the higher up the scale of proceedings that you become involved in, the earlier these issues are likely to be addressed. So, for example, in appeal proceedings, the standard directions that are issued by the presiding member will require you to file written submissions seeking permission to appeal well before the hearing, so that issue is determined well before the hearing of the appeal, so you'll know well in advance. But the point that Nick makes is a valid one and a useful tip. If you ask the member to determine the matter early so that you're certain, because there's nothing worse as if you're a HR practitioner or an individual applicant who comes along with their lawyer, only to be denied representation or permission to be represented by a lawyer, and then having to hand over and run the case. It puts you in a different position. So if you want the matter determined early, most members will accommodate that and give you an answer before the hearing. Addressing the presiding member, from my perspective, it doesn't particularly bother me what you call me, as long as it's not crude names. But let me give you the tip. Some members take great offence if they're a presidential member to be called a commissioner, or if they're a commissioner to be called an acting commissioner or associate commissioner or something else. So it's always best to find out who's hearing a matter and address them appropriately. When in doubt, call them sir or madam is a useful tip. But some members will get quite annoyed, it's fair to say, about improper address, and the last thing you want is to get on the wrong side of somebody who's hearing your case or your client's case on the day. As I said, from my own perspective, it really doesn't bother me, but I do know that it bothers some members, so it's a point that you should bear in mind. Always maintain professionalism. and understand your professional obligations, as I've indicated earlier. And I think, as I indicated at the outset, the best way to improve is to listen and observe the practice of other advocates. Practice yourself. Every opportunity that you get, you should, if you want to be an advocate, you should get to your feet. When I was in private practice, I would be forever pushing younger lawyers into courts in unfamiliar surroundings to get that experience. You wouldn't obviously send them off to a large multi-million-dollar corporate stoush with silk on the other side, but at directions hearings and less formal settings, to give practitioners that opportunity to stand up and to make an argument or to put a particular point of view across. But ultimately, you'll need to develop your own style. Trying to mimic somebody else rarely works. Try and be interesting, try and be concise, and always try and be relevant. And there are some other useful tips which I won't go through, but you can look at in your own time. The ground or the foundations for any good advocate starts with preparation, starts and ends with preparation. You need to prepare and analyse your case, and you need to prepare and analyse your opponent's case. There are four very basic steps which we've highlighted on the slide. Get to know your case in detail, know your case material, and know that of your opponent. Analyse your case for both its strength and its weakness, probe it, and develop a case theory. And a case theory will involve both a factual case theory and a legal case theory. And in very simple terms, a case theory is nothing more than a detailed, accurate story of what occurred. It should be framed in a way that demonstrates to the decision maker why you should win, why your client should succeed, why you should obtain the relief that you're seeking, or why, from a respondent's point of view, the case put against them should be dismissed. It's the essential basis upon which you're going to advance your entire case. It's the basis upon which you're going to lead the evidence that you choose to lead. It's the perspective from which you will approach things like cross-examination of witnesses. In a number of cases, not in every case, there will be some relevant legal issue, relevant point of law that you'll need to understand and apply, and you'll need to be familiar with the rules of evidence and procedure. Now, it is true that the Commission doesn't or isn't required to strictly apply the rules of evidence, but we do so generally, and we do so for very good reasons, and they are concerned with matters of fairness. We may admit material which might otherwise be in a hearsay form, and we'll have arguments about whether or not that evidence should be given particular weight. But it's rare that we'll admit things that are not relevant, and that's just a rule of evidence that a court or a tribunal should only receive evidence that's relevant to an issue that requires determination. So you need to be familiar with evidentiary matters, and you need to anticipate the evidentiary issues that will be put against you, or the objections that might be taken to the evidence that you propose to lead. Again, I never am ceased to be surprised at you have an advocate who will object to particular witness statement on grounds of hearsay, relevance, etc., and go through in minute detail about trying to exclude particular bits of evidence, only to find that their witness statements suffer the same flaws. So pay as much attention to your own witness statements and the form of your witness statements as you do to the other side's, and you'll find that your case will benefit as a whole.
Val, on that point, one of the things which occurs to me, particularly with relevance objections, is that depending on the quality of the advocate, it may not be clear to me at the point the objection is made what is relevant and what is not. Oftentimes the way that things are developed in these sort of proceedings is you have a blancmange of issues that need to be sorted through, and there's an objection in front of you about relevance, and you're really not sure at that point whether it's relevant or not. And that comes back to the point Val was making about really knowing the case material, knowing the case theory, but also putting it in a succinct way that at the start of the case, the tribunal member knows at that point what's relevant and what's not.
The fourth area of preparation is performance preparation. Get up in front of a mirror or in front of your colleagues is usually the best. Again, when I was in private practice, it would not be uncommon for me to, before a hearing where a senior associate was going to run a case, I'd sit there and they would run their arguments by me, and I would test them. And you'll find that you can do that with your colleagues, and it'll hopefully iron out the glitches in your case, perhaps highlight things you hadn't thought of, perhaps in rare cases make you go back to the drawing board and start again and look for a different case theory. But performance preparation is important. It shouldn't be, and particularly when you're new to advocacy, because people do suffer performance anxiety, and this environment can be a daunting environment to a young advocate, particularly if you've got a grumpy member, not Nick or myself, but some others might. Members are human, and they have good days and bad days, and sometimes they're perhaps less attentive to courtesy than on others, and you need to be confident in what you're doing. The best way to be confident in what you're doing is having done it before, and preparation, performance preparation is a critical element of that.
In terms of performance preparation, just be careful you understand the proceeding you're involved in. Is it a conciliation, in which case the aim is to try and resolve the issue, or is it a determination in a hearing or a conference? I see, particularly even with represented parties, a misunderstanding of what the conciliation is about, and they will start trying to persuade me when in fact all I'm trying to do is to facilitate a conversation for resolution of the issue. And it's also then, in terms of performance, misunderstanding how much time you have, how much you actually really need to say. You can assume that the members read most of the material if they've had time. Check in with them whether they have or not, but they will actually have read it, in which case you don't need to repeat most of it, but you do need to focus on the things that are relevant for that purpose, which may be 1 to 2 hours of actually trying to resolve the issues, or setting it up so that in another conference you can resolve it. Now that's all radically different from what you do when you go into a hearing, which may be a lot more formal, a lot more elaborate, and you do need to refer in greater detail to the things in your submissions.
All right. Let's look at some of the things that you might want to consider when you're preparing a case. And I approach this from a first instance point of view. So the nature and extent of preparation on an appeal matter is different because you're looking for different things. You're not trying to establish your case, you're trying to identify error in the decision at first instance, or as a respondent you're trying to support usually the member's first instance findings. Most cases, certainly before the Commission, will turn on their facts. So it's important to consider your evidentiary case and what it is that you're going to be preparing. You start by looking at the nature of the remedy that you're seeking, whether it's an unfair dismissal application, whether it's an application to terminate an enterprise agreement, whether it's opposing the making of a bargaining order, whether it's a dispute under an agreement. All of these various remedies that the Commission is able to give require you to establish certain things. Most of the powers exercisable by a member of the Commission are exercisable upon being satisfied of certain things. So the starting point for preparing your evidence is to ask yourself, well, what is it that I have to satisfy the member about? In the case of an unfair dismissal, if you're acting for an applicant, one of the things that you'll need to consider is whether or not there was a valid reason. And if you're trying to persuade the member that there wasn't a valid reason, then you're going to have to look at what happened. And you're going to have to ask, you're going to have to establish that a particular course of events occurred or didn't occur. So ask yourself, what facts do I need to establish in order for my client to win? The second thing you're going to have to ask yourself is, well, how am I going to establish them? Am I going to lead evidence from the applicant? Who else do I need to lead evidence from? Are there documents that are going to assist me in establishing some of the matters that I need to establish? How will I verify these documents? Where will I get them? Does my client have all the documents? Does some other party have the documents? Is it the respondent that has the documents? Is there a third party, not party to these proceedings, who might have some documents? These are all questions that you'll need to ask in preparing your case. Sometimes you might have to establish facts by cross-examination, and that's the only basis upon which you'll be able to establish that your version of events is that which occurred. In preparing your case, you should ask yourself, well, which facts are going to be disputed and which facts can I establish by agreement? Not everything in a case is disputed. So spend some time working out what it is that is in dispute. It's those things that you're going to have to prove. If you're able to reach an accommodation with your opponent about certain facts which are critical to establishing the cause of action or the nature of the support for the application that you're making, then it's worthwhile spending some time trying to agree on some facts so as to avoid the cost and expense of and sometimes the difficulties that witnesses have in giving evidence. I mean, some people are very reluctant to give evidence in these sorts of proceedings. So if you can avoid all of that, you should spend some time doing that.
Can I make a special note about video evidence? I think there's a special place in hell for people who make me view hours and hours of video evidence. Having said that, it is problematic. Very little video evidence is actually stands for what it is that the advocate tries to put to the Commission. Nonetheless, that's obviously your entitlement to bring that forward. But there are some practical difficulties, not the least of which is obtaining it if you're not the respondent in the matter. The experience we've had in the unfair dismissal jurisdiction is generally CCTV footage is recorded over within a very quick period, within about 7 days or 14 days of it being recorded. So you do need to move quickly, but then you do need to ask yourself, does it actually show what it is that you're endeavouring to put forward? Often, I've only seen one piece of video where the quality is sufficiently good to actually understand what went on, and that involved a bus company which was ferrying school children, and it actually had 5 cameras around the bus, and it was only at the end of the conciliation I realised it had audio. And so at that point you knew exactly what went on. It was HD, all 5 cameras, all simultaneous, but most is the classic petrol pump CCTV footage and you've got no idea what's going on. So be careful.
Yes, video evidence can be quite tricky. I recently had a case where there was an allegation involving theft from a store, and there was some CCTV footage. And the case theory advanced by the applicant in that case was that this particular item that the employee was said to have taken was already in his coat pocket, and he went to the store to measure up this particular item so he could purchase another one. And we had lawyers galore for both parties who trawled over all of this video evidence. And there's this one bit of video evidence which showed the worker, the employee coming into the store, and it happened. It must have been windy in the entrance, but his coat was blown out this way, and you could see his inside pocket where the so-called item that was brought into the store was supposed to be. Nobody bothered to blow that up to see whether there was in fact anything in the pocket. As it turned out, there was nothing in the pocket, and the case theory died, and the case discontinued. So if you're going to use video evidence, please look at it closely, is the moral of that story. Sometimes issues of, not in every case, but in many cases, issues of law will arise that might require an interpretation of a particular provision of a statute on which you're relying. It might be relevant authority on the proper interpretation of the section of the Act on which you're seeking to place emphasis. Identify them, ask yourself how the questions of law arise in your case, how will you need to address them, and so forth. It's useful to alert the member to relevant cases, but please don't overdo it. Often, there will be one or two leading cases on a particular point that you want to make. You don't have to bring along the 10 cases which basically repeated what the first case said. Be circumspect in the manner in which you present cases, but understand the case from a factual point of view. It's very rare that you will have a case upon which you rely upon that can be understood in the abstract. All cases are decided upon the facts. It's important to understand the proposition for which the case stands, understood in the context of the facts in that case. If the facts in that case don't match the facts in your case, then the authority on which you seek to rely isn't going to be very helpful at all. So don't present cases about which you know little about the facts. Most members, certainly I will engage you on the facts of a particular case if you bring it to my attention. Where there are, as I indicated earlier, where there are cases which are against the proposition that you want to make, then alert the member to them, try and distinguish them on the facts if you're able, and don't be afraid if you think that a case was wrongly decided to put the proposition. Particularly when you're dealing with first instance commission members, a bit harder to do so on an appeal where you're arguing a case before a first instance member to argue that the decision was wrong unless it was clearly wrong. But don't be afraid, if it serves the interest of your client, to try and distinguish cases on which the other side relies. We have available on our website bench books which deal with a range of the various kinds of matters that we frequently deal with in the Commission. There are practice notes online available about the appropriate steps that parties should take in respect of particular types of matters. They're useful resources, but don't treat them like the Bible. The cases, for example, in the bench book are there by way of example, not as authority for any particular proposition. They just give examples of the way in which a particular case in a particular factual scenario was decided, to give mainly unrepresented but also represented parties some indication as to the way in which matters might be decided. Before you come to a hearing, make sure that you file all documents on time. Commission doesn't issue directions for fun. It expects compliance, and if you want an extension, it's best to ask for it before the time expires. You usually get a better response. You want to file your documents on time, not just for the purposes of putting the other side on notice about the case that you want to run. You'll avoid delay in having your matter dealt with if you're an applicant, or if you're a respondent, having the matter determined, because once you start filing documents late, there will invariably be a complaint about fairness, wanting extra time, perhaps an adjournment of the proceedings. The second reason is that most members will read the material that you file before the hearing, because they want some familiarity of the case, so they can engage with you on a proper basis, and so that they'll have some understanding at least of the issues that need to be decided. So you'll do everybody a service if you file your documents on time. As I've indicated before, try and reach agreement on the facts, try and reach an agreement with the opposition about the order of witnesses or the order of proceedings. Who's going to go first? In what order will we call them? If there are particular requirements of a particular witness, a medical practitioner can only be here between 12 and 2, make those arrangements beforehand. It'll be easier to manage the proceedings and avoid unnecessary delay. If there are special circumstances, facilities that are required, if there's some particular urgency about a particular application, you should communicate that to Chamber so that you can any special requests can be accommodated.
It's also quite common in our jurisdiction that we deal with evidence through telephone or video conference or Skype or any other mechanism you can think of, and that doesn't necessarily accord with how the other side on the party wants it to be done. But usually we will find a way for the evidence to be brought in if there's no real alternative to be able to do that. But what we always say to parties is that you need to identify that beforehand, so that first of all any objections can be flushed through, but also we can make the arrangements. It's not necessarily desirable to take evidence by telephone, but if that's the only alternative the member has to significant delay, then maybe that's what has to occur. And so we do try to accommodate the parties. But obviously we take into account the objections when it comes to the matter of weight and all the rest of it.
Preparing your witness. As I think I've made the point more than once, cases will turn on the facts, and the facts will be borne out principally, not exclusively, but principally by the witnesses that are called to give evidence in a proceeding. So in the normal course of events, members will make directions for the filing of material, including witness statements, in advance of the hearing. So the evidence, at least in chief, is in a written form. But you'll need to prepare the witness. You'll need to explain to her or him what they should expect. If you've got a particularly nervous witness, it's not a bad practice to bring them into the Commission before the hearing, perhaps when there's a hearing on, and let them sit in the public gallery to observe what happens so that they're not caught by surprise on the day they give evidence. Have them read their statement. When you prepare their statement, prepare it in their words, not yours. Your witnesses aren't lawyers, and there has been a witness who has come a cropper during cross-examination because they didn't understand a concept in their own witness statement because it's the lawyer's words. So prepare the witness statement in the language that your witness uses, not in your own language. Alert them to the fact that they'll be required to take an oath or affirmation. Explain to them what that is. You don't want them having to make those decisions when they're already nervous in a witness box. Explain to them that they'll be asked, explain to them what that involves, and so that they're not caught by surprise. If your witness has particular religious requirements for the taking or administration of an oath, then you should alert chambers to that beforehand so that the appropriate instrument upon which the oath is taken can be available in the court. You need to be sure to ask your witness enough questions so that you're satisfied that you've been told the whole story. There is nothing that brings a case to a conclusion more than the witness during cross-examination bringing up a fact that they haven't told you about, or a fact that they haven't put in their witness statement. It might affect their credibility, it might affect the way in which the overall case is viewed by the member. So take time to prepare your witness, take the time to cross-examine your witness before they give evidence so that you are across the case. Don't coach them though. Don't put words in their mouth. Don't try and persuade them to say something in a different way. But prod them. Make sure that you understand what their evidence is going to be before they give it. You understand what answers they're likely to give during what may sometimes be a vigorous and fulsome cross-examination. Break propositions down for witnesses in chunks that they can understand. Witnesses have different levels of education, different levels of understanding, different experiences, so you need to be able to elicit the evidence in a way that your witness comprehends.
In terms of preparing for evidence, a couple of things I would say is that it's quite common for witnesses to say in cross-examination to a question, I don't have to answer that. And what they mean is in a normal meeting, they would not disclose information about that person. It might be private, they don't want to refer to it, it's inconvenient. You need to say to your witness, they do need to answer, unless it's disallowed by the member. The issue of privacy is something we'll work around, but ultimately there's no privacy in the Fair Work Commission. It's a public hearing. The other issue is try to encourage them to understand that they're not there to advocate, they're there to answer questions. The more they advocate instead of the advocate, the lower the case goes in some respects, because they're seen as just not being capable of answering yes or no.
Before we come to the conduct of the hearing itself, just make sure that you've read and understood what the hearing's about. It's usually disclosed in the notice of listing. Make sure you've understood the directions that are made and you've complied with them. A general rule, if you're in doubt, ask. Ask what is required. Identify all the documents that you'll need to have in court. Enough documents for a witness, for example. Enough documents for the other side, enough documents for the member so that they can all follow the course of argument and the course of the proceedings. If you've agreed on a statement of facts or have a chronology prepared, which is always useful, have them available at the hearing, you can hand them up. And if you're relying on video recordings or voice recordings, it's always useful to have indexed the video or the voice recording so that you can instruct the associate to take the recording to the particular passage that you want to rely on. There's nothing worse than having to scroll through hours of CCTV footage or hours of audio recording just to get that little chunk that you want to rely on. So have it indexed, give that information to the associates so that we can get to the point that you want made. All right, so we've already dealt with permission to appear. So opening, you arrive at the hearing. Look, at the beginning of a hearing, members have different practices about taking appearances. Some members will simply say, I'll take appearances, and if you're a first-time advocate, this will be your first opportunity to stand up and ease the nerves and announce your appearance. But if you're before me, that won't happen. I know who's appearing for me. My associates have taken the appearances, and I'll just simply tell you that you're appearing for Fred, aren't you? And you'll say, yes, if you're ready to go like this, you'll have to come to. So be prepared for different approaches by members about the appearance. But generally, at the start of a proceeding, there'll be some form of opening statements. But take the time to ask the member what their preference is. My own preference is that I don't need an opening statement. You've usually filed an outline of submissions. You've said what you want to say in that by way of opening, and it's not something that I'd require. I'd rather get on with the evidence. So again, be mindful of the members' preferences, and the best way to be mindful is to ask them whether they want one or not. If you desperately want to make one, I'm not going to stop you making it. But I have read your outline. I know what you're going to say, so let's just get on with the evidence. But if that's what makes you feel more comfortable, I'm certainly not going to stand in your way if you really want to make one. But that's not where your case is won.
And I follow the same procedures, essentially. The exception is the hopefully rare matters where I haven't read the file. And it may well be because I can remember a few instances which have come in at urgent matters, and you simply are not aware of what it is, and you require an opening. But the normal matter, you don't. You've read the file, you're ready for it.
A 418 application is a case in point where
Yes.
you've got industrial action alleged to be happening, someone seeking an order to stop. All you've got is the basic application and a sketch. So sometimes in those circumstances it will be useful, but in the normal course of events, orderly directions are made. Your case, at least at first instance, is in writing. Your opening is in writing. But if you're going to make an opening statement, don't read the outline that you've filed. It should just be a simple narrative of your case. It needs to be consistent with the case theory that you're trying to advance. It should be told as a persuasive story, directed to a particular outcome, particular legal result. You don't need to engage with the case that's going to be put by the other side. Just tell the case that you want to advance, set the scenario, identify the key issues, and explain briefly how those key issues are going to be resolved, and from your perspective, resolved in favour of your client, and try and be concise. It's not where you will make your case. I can't emphasise this enough. Cases are won on the evidence, not on the oral argument, certainly not that which is advanced in the opening statements. When you make your opening statements, if you make one or if you put it in writing, don't exaggerate the strength of your case and don't make statements that you can't prove. It is pointless making an argument or advancing a proposition which you know you can't prove. It just undermines your case theory, undermines the position of your client.
Before you go on, pal, I noticed on the other slide that there was a reference to a chronology.
Yes.
They are gold, if they are accurate. Okay. So often, particularly in unfair dismissal matters, we don't get a decent chronology. If you can get an agreed one, you've just been elevated to my Practitioner of the Year award. If you can't get agreement, then put yours forward, because it saves me hours of work of trying to sort through what occurred on what day, and that an equally an agreed statement of facts, which is beyond Fred was employed on the 1st of April and dismissed on the 13th of September. Again, they're gold.
You'll be given an opportunity to call your witnesses. In the normal course of events, the applicant will go first and its witnesses will be called. The respondent's witnesses will be called subsequently. At the end of the proceeding, there'll be oral argument or sometimes written argument, depending on the preference of the member and sometimes the complexity of the case at hand. But in most cases, you'll be given an opportunity to prepare a thorough and complete witness statement. Again, I emphasise, prepare it in the witness's own words, not your words. But if you are in a case where you're going to have to examine your witness, that is, you haven't had an opportunity to prepare a witness statement, for example, in a 418 application, generally you won't have had the opportunity to prepare a witness statement. You'll have to have your witness give their evidence orally. The purpose of the examination in chief is to give the witness an opportunity, to the extent that the witness can, give a detailed story or part of the story of the case that's being run. It's told by the witness, not by the lawyer. It's in answer to non-leading questions. Some people struggle with that concept, but it's questions that are open, ones that don't suggest the answer to the witness. The tribunal member wants to hear what the witness has to say, not what the lawyer has to say about the evidence. The witness was there, the lawyer wasn't. The answers that are to be given or the evidence that's to be led should be relevant to an issue that's to be determined, and usually given in a form that's admissible. As I indicated earlier, we're not strictly bound by the rules of evidence, but most members will apply them just on fairness grounds. But the way in which the evidence is to be given is you've got some control over that. The way in which you ask your questions, the order in which you ask your questions is controlled by you. You have some control about the way in which the story is told, so you control the way in which you ask the questions, the order in which you ask the questions, but again, be mindful of the case theory that you're trying to develop. And hopefully the evidence is given persuasively, and it'll be given more persuasively if the witness tells his or her story. One final note about evidence in chief, whether it's in a witness statement or given orally. If your witness, if there's bad stuff to tell about this story, it's better that the witness tells it rather than having it dragged out of him or her during cross-examination. So if there's something that doesn't help your case but is relevant and should be admitted because it's going to come out, it's better that the witness tell that to the tribunal member than it coming out later. We'll deal with some issues of cross-examination. Cross-examination has many purposes. Not each of these purposes are relevant in each case, but sometimes what you want to do with cross-examination is elicit favourable evidence to support your case. Sometimes you will want to, you'll find that the witness is actually helpful and you want to positively accredit that witness or the evidence that witness gives. Sometimes the witness is not helpful and your job will be to try and discredit the witness, not by attacking them as such, but undermining the evidence they give through the cross-examination that you undertake. And sometimes you'll want the witness to concede a particular point or to place a different complexion on the evidence that they're giving. To be an effective cross-examiner, you're going to have to understand the purpose and scope of the cross-examination. So don't just ask questions for questions' sake. Sometimes you won't need to ask any questions. Sometimes the evidence that's led is so tangential to an issue that you think is relevant for your case that you won't need to ask any questions. The most off-putting thing for your opponent is when you say, I have no questions, because then they're left there scratching, wondering, well, what is it that I haven't done? correctly. I mean, you shouldn't use that as a strategic mechanism, because sometimes you have to ask questions, but understand that it's not necessary to cross-examine every single witness. Some things that witnesses say are not controversial. I mean, for example, in a termination of an agreement case, where employees come along and they give evidence about the impact of the termination of the agreement on their terms and conditions of employment. Those things are not controversial. It necessarily follows that if an employee who's on an agreement which pays 3 times the amount of the minimum rate in the award, having the agreement terminated will have an adverse impact on the employee. Pointless cross-examining that witness about their view of the impact. So be mindful of when you need to cross-examine and when you don't. Again, understand that the relevant rules about evidence and their application. Cross-examination should be directed to your case theory. You need to control the witness, and I'll come to that. You need to structure your questioning. And you should adopt a gate closing technique in relation to cross-examination. I'll show what that might involve in a particular circumstance. But essentially, what you're trying to do is to ask simple questions in a particular order in order to leave the witness no room to wiggle out of things. Now, take an example that occurs very frequently. That is, in cross-examination, a witness will say something that wasn't in their witness statement. Now, yes, you could jump down their throat immediately and say, well, that wasn't in your witness statement. You're telling a fib now, aren't you? And they'll say, no, I'm not. I just remembered it. A better way of perhaps approaching that issue, either at the beginning of your cross-examination or when this particular fact falls from the witness's lips, ask them a series of questions. And for example, you might start with saying, well, you adopted your witness statement, when you made your statement, your lawyer was very patient with you, wasn't he? Yes. And you were doing your best to tell the lawyer the truth, yes. And you were trying to tell your lawyer the whole story, weren't you? Yes. And you told them every important detail, didn't you? Yes, I did. And you didn't deliberately leave anything out, did you? No. And when you made your statement, your lawyer asked you to sign it, read it, sign it. Yes, yes. Make sure it was accurate. When you adopted your witness statement today in the witness box, you were asked whether it was truthful and accurate. Yes. And you adopted it as truthful and accurate, didn't you? Yes. And you were asked whether you want to make any changes or corrections. Yes. And you didn't, did you? No. And your memory of the incident was better when you made your statement than it is today, isn't it? Wasn't it? It's a bit hard to argue with those sorts of propositions. And you didn't say anything in your statement or to your lawyer about this new fact, did you? And that's all you have to do. Now, the options for the witness are minimal. They either genuinely remembered it and didn't tell their lawyer about it, or they're making it up because they were under pressure. So you don't need to attack the witness, you just need to close the gate. It's best to do that at the beginning so that you've already set the scenario in case the witness says something that you weren't expecting. You should also consider in cross-examination about how you use documents and whether you can use documents effectively. Sometimes you might need the witness to verify documents that you have that you want to rely on, and this is your opportunity in cross-examination. All adverse allegations that your client is making about the witness should be put to the witness to give them an opportunity to answer, to test them. You should be consistent in your demeanour throughout. There is little point to becoming confrontational or aggressive, ask your question and move on. Often the witness will never agree with you. Just put the proposition that you want to put and move on. And assess the risk of unhelpful answers being given in the questions that you ask. And if you're going to ask those questions and you get an unhelpful answer, you need a strategy to deal with how to manage them. I describe these as 10 commandments. They're just rules of common sense, really, in cross-examination. Be brief. There's no point embarking on a 2-day cross-examination of a witness when really you want to just get a particular point from the witness. Ask short questions, use plain words. Unlike in examination in chief, only ever ask questions in a leading way. Put propositions to the witness and get them to agree as best you can to the propositions that you're seeking to advance. It's always wise, I think, not to ask a question about which you don't know the answer. Fraught with risk, just running a kite up and seeing where it lands. It will usually involve damage to your case. Listen to the answers that are given, because the answer given might open up another line of inquiry that you hadn't thought of that is important to your client's case. As I indicated already, don't argue with the witness. Don't allow the witness to repeat their evidence in chief. They're already given that. You want them to answer the questions that you're putting. Don't allow the witness, if you can avoid it, to explain things. Now, I say these are 10 commandments because I talk about these from an advocate's perspective. When I'm up here, and if a witness wants to elaborate, sometimes I'll let them, because I'm interested in what they're going to say. So don't be. You might want to corral the witness, but I want to hear what they say, so I'll allow it. So just be prepared for that. Importantly, know when to shut up, know when to stop questioning, and don't ask witnesses in cross-examination or in chief to make conclusions about the evidence, or what they think about a particular state of affairs. Just ask them about the facts and no more. Leave submissions to the advocates. Final submissions. It's always helpful if you're able to set out your final submissions in writing. It'll be helpful to the member hearing the case, and it'll be helpful to you to organise your thoughts. That will not be possible in every case. In urgent applications, you won't get the luxury of putting your submissions in writing, so you'll have to fly by the seat of your pants giving oral submissions. But generally, I find written submissions filed after the evidence is in, where parties have had an opportunity to review the evidence and structure their submissions based on the actual evidence that's given, rather than as at the beginning, evidence they anticipate to be given, because the two things are not always and often are not the same. Talk to the member, talk to the other side about whether or not written submissions should be given.
I think I'd agree with that they are more valuable if they're in writing and they're considered. The very best advocates are able to have that prepared and hand up at the end of the evidence, really, but that's obviously at the extreme end. And usually the reality is the member's not about to issue a decision that afternoon or even next week, and so time is not particularly an issue. That if you think it is beneficial, ask for the time.
If you want to make oral submissions as well, again, that can be accommodated. It's not uncommon for me to set down a program for the filing of written submissions and then giving each party a short opportunity to address me orally on matters. In fact, I find that a useful exercise, because I can then engage with the advocates about the propositions they put in writing. I can test the matters that they set out in their submissions, and from their perspective, they get an opportunity to have some knowledge about whether or not I understand what it is that they're putting. The worst kind of judicial officer or member that I've encountered as an advocate is the one that sits up here mute, says absolutely nothing during a 3-day hearing, and I have no idea what they're thinking. It's not helpful. So certainly from my perspective, I engage a lot with the advocates, and don't come along to a hearing ready to speak to your written submissions, because usually I won't let that happen. There are questions that I have that I want you to answer, so be prepared for that. But essentially, your final submissions, your argument should be structured, a set of structured propositions, supported by reasons, by reference to the evidence that you give, that has been given. They should be persuasive. This is your opportunity to propose conclusions of fact or law that should be made, identify the factual findings that you want the member to make, and again, you go back to the beginning. What is it that I have to establish in order to win my case? This is the evidence that I've led. This is the evidence that the other side has led. These are the factual findings I want the member to make for the purposes of coming to this conclusion, which supports my case theory. It's to be directed to the desired result. A good final submission is logical in its reasoning, it's structured, it's credible, it explains each issue, why it's relevant, how it should be resolved, why it should be resolved in, excuse the typo, in the way in which your client wants it to be resolved. Importantly, a good final submission will also make sensible concessions. You'll find that in the course of a case, some things don't go your way, and you should be prepared to concede factual issues if they become inarguable, rather than maintaining the position you adopted at the beginning of your hearing. Giving an oral submission, whether it's supported by written submissions or by necessity having to make an oral submission at the conclusion of evidence, requires a number of things. I just want to highlight a couple of things. I think, as I've indicated already, my general approach is to engage. So I will ask a lot of questions. I will try and summarise arguments that a party or an advocate is putting, try and get to the kernel of the argument. So it's important that as an advocate you listen to what the member is saying, and also endeavour to answer the question when it's asked, for a very simple reason. I only ask questions that I think are relevant to an issue that I have to decide. When I ask it is the time at which I'm thinking about it. If you say to me, oh look, I'm coming to that, A, you may never come to it, because you may have forgotten it, and B, I won't be thinking about it at the time, and I may not ask it again. And so you've lost an opportunity to influence me in relation to a matter that I've been thinking about. Now, that said, sometimes you'll be asked a question that you'll need some instructions on. So don't be afraid to say, look, Deputy President, can I have 5 minutes with my client to get some instructions? Or that's actually a very complicated question. Can I have leave to file a short written note at the conclusion of the proceedings? Because it's not as simple as you think it might be. Don't be afraid to deal with questions in that way, but don't put them off. Deal with them one way or the other. Then don't just simply say, at least from my perspective, don't say or avoid saying, I'm going to come to that later, because it doesn't suit the way in which you've prepared to argue your case. If I've asked the question, it's because I'm interested, and this is your best opportunity to persuade me.
And similarly, don't fob off the question with an answer on a completely different topic. Many will try to do that, but at the moment that occurs.
It's reserved for question time in Parliament.
Yeah, please no.
All right. Mindful of the time, Kate. Look, because I am getting to the next slide. Just a question of style. Try and avoid meaningless cliches. There are some. For example, if you disagree with the proposition that I've put, again, for me, it doesn't matter if you say, look, respectfully, Deputy President, blah, that doesn't bother me. Some members, it's like red rag to bull, because they'll say things like, I know what that means you think I'm a complete idiot and I've got the wrong end of the stick and I find that offensive, you know. So just avoid them if you can. They don't add anything to the line of argument. Continuously saying things like, it's our submission that, again, it's just unnecessary verbiage. Make your points once. Don't repeat them. A good argument made well serves you well made once. Repeating a bad argument doesn't make that argument any better. And when you're constructing your case and your argument, just remember you might have 10 points you want to make, but be discerning about them. By all means, make them all in writing, but when you're giving your oral presentation, perhaps pick the 2 or 3 best points that you have, because they're the things that you want to highlight. You want to highlight the strength of your case, not these other tangential points which you'd like to get up on, but don't really make a great deal of difference to the outcome of your case. Kate, you want to get up and talk about this? No? Right. This is some detail, not so much for advocates, but for unrepresented litigants. It would be unsurprising to most of you that significant portions of our work involves dealing with those that are not represented, either by choice or because they can't afford it. We've developed a workplace advisory service which assists both unrepresented parties in particular categories, particularly respondent employers in small businesses, but it also helps the Commission manage its workload, file management and general conduct of matters. So the Workplace Advisory Service has been established through the assistance of a number of law firms who provide their services on a pro bono basis, and the services they provide range from an advice service at the initial application stage to representation before the Commission, subject to permission being granted, either in jurisdictional cases or in some cases running a full hearing before a member or participating in a conference. They're the various levels of assistance. Unrepresented litigants, as I indicated, take up an enormous amount of time in the Commission, and we're very grateful to the law firms that assist in providing advice to both employers and employees in the range of matters. Now, we don't make the service available for every single kind of application that is available. They're generally confined to general protections matters, bullying matters and unfair dismissal applications. There's lots more information available on our website, but for those of you who are members of the participating firms, we're very grateful for the service that you do provide, and it's also a great opportunity for young lawyers to get advocacy skills that they, particularly at the larger firms, that they may not otherwise get because of the nature of matters that those firms deal with. There are resources that help unrepresented parties in the form of bench books. They're also quite valuable for particularly younger practitioners in the Commission, and there are lots of other resources available on the website which you might want to have our website and others which you might want to have a look at, which might assist in your career as advocates.